This is the second antitrust lecture video. This is on the Clayton Act and the Federal Trade Commission Act. The Clayton Act of 1914. Let's first start with the key provisions of the Clayton Act. Section 2 prohibits price discrimination where the effect of such discrimination may be to substantially lessen competition or tend to create a monopoly in any line of commerce. Now, the language may be to substantially lessen competition or tend to create a monopoly is consistent. Notice how that differs from the Sherman Antitrust Act, Section 1 and Section 2. The Clayton Act can be forward-looking, whereas the Sherman Act deals with present or past. Section 3 of the Clayton Act prohibits exclusive dealing contracts and tying arrangements. We've already talked a little bit about tying arrangements, where the effect may be to substantially lessen competition or tend to create a monopoly in any line of commerce. An exclusive dealing contract is one in which the parties agree that you won't sell, that you can only sell my goods and not any other manufacturer's goods. Or you agree to buy my goods and not to buy anyone else's goods. You have to deal exclusively with my goods, either as a buyer or a seller. The agreements between franchisors and franchisees, however, that limit the products that a franchisee can sell, these are not exclusive dealing contracts. Tying arrangements, as we have discussed, I will only sell to you if you agree to purchase these other goods or services from me. And then third, key provision is Section 7 of the Clayton Act. This Section 7 of the Clayton Act is amended by the Seller-Kefauver Act, and it makes it unlawful to acquire another corporation if it will tend to create a monopoly. All right, let's go over each one of these separately. Section 2, Clayton Act, price discrimination. The specific piece of legislation that amended Section 2 is the Robinson-Patman Act. This basically deals with marketing. And the Robinson-Patman Act states that it is unlawful for a seller to discriminate in price between different purchasers of goods of like grade and quality, where the effect of such discrimination may be to substantially lessen competition or tend to create a monopoly in any line of commerce, or to injure, destroy, or prevent competition with any person who either grants or knowingly receives the benefit of such discrimination, or with customers of either of them. Basically, here's the evil of price discrimination. We're going to give, in this particular case, the dominant party, and it may very well be, a firm that has the ability to control the market and control the price, is I will sell to somebody else cheaper than I will sell to you. Therefore, they will have a price advantage over you. I guess probably the easiest is looking at it from the perspective of a monopsonist. With regards to a lot of products, and by virtue of their size, really, a firm like Walmart may have the powers of a monopsonist. simply because that sellers, manufacturers, need to be on the Walmart shelves. And so they may have to sell. Walmart may very well drive the price down so much simply by virtue of getting on their shelves that they may drive the price down well below what the manufacturer can afford to sell to anyone else. Hence, Walmart might be given a superior price and a superior competitive advantage over other retailers. All right, so what we look at within price discrimination to see whether or not it's unlawful is we look for an explanation for these price differences. Sometimes manufacturers or distributors can afford to sell to someone at a lower price than they sell to someone else simply because of the cost of manufacture. Maybe it's production runs. A larger production run makes the cost of manufacture cheaper. Maybe the delivery. You're delivering in larger quantities, therefore the delivery costs are less. Or maybe the transactional cost in sales, meaning the sales commission can be less. Well, anyway, within price discrimination, if you can explain the difference in the price under facts and circumstances, then it's not an unlawful price discrimination and a violation under Section 2 of the Clayton Act. But if you can't explain it, then the price discrimination can be unlawful. Now, a price can be reduced to meet the price of a competitor without being actionable. Should be noted that Section 2 of the Sherman Act, Section 2 of the Clayton Act, under this Robinson-Patman Act, it's really a paper line. There's not enough prosecution by the Federal Trade Commission or injured parties for lawsuits on them. Occasionally there will be one. In an old case, 1948 Supreme Court case, Federal Trade Commission versus Morton Salt Company, Morton Salt was being prosecuted by the Federal Trade Commission under Section 2 of the Clayton Act for price discrimination when it sold its product to some customers at a substantially better price than to others. Here, the Supreme Court held for the Federal Trade Commission that the prosecution defendant, meaning here Morton Salt, must show that the price discounts were justified. And it held that the Federal Trade Commission must show that the price discrimination may, meaning it doesn't have to be will or does, may substantially lessen competition. Second violation is under Section 3. First, let's deal with exclusive dealing contracts. So in this particular case, in sales or leases, the seller or lessor may not transact business on a condition, agreement, or an understanding that the purchaser or lessee shall not use or deal in goods of a competitor of the seller or lessor, where the effect may be to substantially lessen competition or tend to create a monopoly in any line of commerce. The deal is, the only way I will sell to you is if you give me exclusivity. You only buy my goods. You don't buy from anyone else. Or you only sell my goods and you sell no one else's. Here, the defendant seller must have a substantial share of the market, but it doesn't have to occupy a dominant position in the market. Basically, that means there has to be enough power that the seller has over the buyer. Now, in a requirements contract, and a requirements contract is a contract in which one party agrees, meaning the buyer agrees with the seller, that the buyer will buy all of the goods that it requires from the seller. This differs from an output contract, and in an output contract, the buyer and seller agree that the buyer will purchase all of the output of the seller. But here we're talking about the requirements contract. Well, in a requirements contract, there's a violation under Section 3 if there is a substantially lessening of the competition. Now keep in mind that the buyer may very well want to negotiate a requirements contract in order for to obtain a lower price and greater assurance that the seller will be aware of its needs and will give it a better service. Secondly, the tying arrangements under Section 3. We've talked about tying arrangements under Section 1 of the Sherman Act. But here, we're focusing on what the language may tend to substantially lessen competition or tend to create a monopoly. So here are the tying arrangements. The goods desired by the buyer require that the buyer must purchase other goods and services, goods or services, from the seller. Again, Section 3 of the Sherman Act has the language substantially lessen competition or tend to create a monopoly. Seller's defense is business justification to undertake the tie. For example, if the agreements between the franchisor and the franchisee, take for example Baskin-Robbins ice cream, and the products must be purchased by Baskin-Robbins franchisee. It's outside Section 3 if it's done under a franchisor-franchisee relationship. All right, the last of the key provisions of the Clayton Act deal with mergers. And by mergers, we're talking about, broadly speaking, acquisitive reorganizations of businesses. Section 7 of the Clayton Act. And the key legislation here is the Sellar-Kefauver Act, which amends Section 7 of the Clayton Act. And this provision says that one corporation is prohibited from acquiring the whole or part of the stock of another corporation or the assets thereof, where the effect may be to substantially lessen competition or tend to create a monopoly in any line of commerce in any section of the country. As with monopoly, we have to consider the relevant product market because we're considering competition, the effect on competition. Well, let's look at the possible ways that one company may acquire another company in an acquisitive reorganization. The first is by merger. Now, we usually use this concept of merger, broadly speaking, a lot like we do trademarks. Because in trademarks, we're talking about intellectual property rights in terms of marks, and there were 4 different types of marks, and trademarks was one of those 4 marks. Well, here we talk about merger, we're talking about the business combination. But, so we've got the general notion of merger, And then we've got the specific definition of a merger, and here, that's where we are here. Specifically, defined merger is two companies agree to combine, and one of the companies survives with all of the assets and the liabilities, and the other company dissolves. A and B agree to merge. That may very well be through the exchange of stock or cash and stock. And then one company survives, company A or company B, and the other company goes out of existence. But all of the combined assets of the two companies and the combined liabilities of the two companies and the combined equities of the two companies all stay within one company. The second type of acquisitive reorganization is a consolidation. Again, this is by definition. Here is one. Consolidation takes effect when two companies agree to combine and a new company, meaning a third company, is created and the two companies that are combining goes out of existence. Company A and Company B agree to combine in an acquisitive reorganization. Their assets and liabilities are combined in Company C, a new company. Old companies A and B go out of existence. That's a consolidation. And then number 3, a business acquisition through an asset purchase, where the insurgent company, the buyer, purchases the assets, substantially all of the assets, of a target company, the seller, including the target's name and goodwill, and the insurgent buyer operates using the target company's name and assets and customers. The target company is then dissolved. Very common. Well, let's look at the types of mergers and how they affect Section 7 of the Clayton Act, whether or not they're a potential problem or not a potential problem. The first is the problem area, and that's a horizontal merger. This is one in which two competing firms at the same level of production, hence horizontal, same level of production or distribution network. Let's suppose, take for example, the merger of Mobil Oil and Exxon Oil to create a company, Exxon Mobil. And this is the most troublesome because it has the greatest effect on competition. The next is the vertical merger. And a vertical merger is when two firms at different levels of production or manufacture combine. This type of merger may, but usually do not cause antitrust problems. Let's give you an example, a couple of examples, or an example. In the 1970s, DuPont, a large chemical company that manufactures a lot of its products from petroleum, was concerned with the first Arab oil embargo from 1973. And so late in the 70s, it decided to reduce its risk of acquiring raw materials from petroleum. So it purchased Continental Oil Company. I believe that was headquartered in Oklahoma at the time. And so they're the manufacturer of plastics acquired the vendor to provide it with supplies. And then we have the third type, which generally cause no antitrust problems at all under Section 7 of the Clayton Act. and this is a conglomerate merger. A firm in one industry merges with a firm in another industry. You can see that they're not competing, and they're not affecting the market. Think in terms of the 1980s, after the leverage buyout craze, in which the tobacco company R.J. Reynolds merged with Nabisco Company, the food manufacturer, cookies and things of this nature, cookies and crackers, and when they formed RJR Nabisco. This was a conglomerate. One of the problem areas of Section 7 of the Clayton Act is the approval process, the merger approval process. The Federal Trade Commission has jurisdiction over the merger approval process. Before two large companies can combine, in which there is a high industry concentration ratio, it has to be approved. The merger has to be approved. It should be noted that in some industries, the Federal Trade Commission does not have jurisdiction over them, but other federal agencies have jurisdiction over competition. Take, for example, for telecom and media, the Federal Communications Commission, or with regards to the airline industry, the Federal Aviation Administration, FAA. The Department of Justice may also get involved if they think a merger might be bad for the citizens of America. Now, keep in mind also that the U.S. is not the only one that goes through this approval process, and the Federal Trade Commission or any of these other agencies do not speak for the rest of the world. The European Union has a strong and vigorous, probably even more vigorous, merger approval process than the U.S., and they are more vigilant in the EU in protecting competition than I would say that we are in the U.S. So, this merger approval process through the FTC or the other agencies are required to follow the Hart-Scott-Rodino Merger Approval Act. And Hart-Scott-Rodino provides the approval process. Meaning you can't, two companies combining cannot go through this merger, assuming that of the size, until they go through the merger approval process. Now, Hart-Scott-Rodino requires that the firms merging must be evaluated of the effect of the merger on competition by calculating the HHI index, the Herfindahl-Hirschman index. And Herfindahl-Hirschman index, HHI, looks at the competition before the merger and after the merger. And if there shows too much of an effect, then the merger will not be approved. I want you to think in terms of the 2001-2002 proposed merger between DirecTV and Dish Network. Now, you recognize both those names, DirecTV and Dish Network. These are the two biggest of the satellite television services. Now, in the late 1990s, DirecTV had gone through a buying craze. They had bought up probably one of the leading satellite TV providers called Primestar. There were, in essence, in the late 70s, there were 4 principal satellite television services, television broadcasting services. Now, I'm talking about the small satellite dishes. I'm not talking about, the 10-foot satellite dishes, the monster dishes from the 70s and the 80s. Well, the 4 principal competitors that made up the overwhelming lion's share were Dish Network, which is more of a West Coast and rural provider, DirecTV, Primestar, and USSB, United States Satellite Broadcasting. In a very short period of time of 1 or 2 years, DirecTV bought up USSB and Primestar. Hence, the DirecTV, then owned by RCA, was the dominant player in satellite television broadcasting, or satellite transmission, or satellite TV, and of course Dish Network. Now, also keep in mind that what you had coming out of the 1990s, 1980s, 1990s, for the most part, was you had local broadcasts. Were not all local stations were broadcast by the satellite television company, not like it is today. So, in the late 1990s, the large cities had their main networks broadcast: ABC, CBS, NBC, Public Broadcasting, and Fox. Local stations generally weren't. In the rural areas, or outside of the major metropolitan areas, everybody else would either get broadcasting of these networks either East Coast or West Coast. For example, in the late 1970s, if you lived in Jackson, Tennessee, or certainly outside of Memphis, you would not get any Memphis broadcasting, and all you would get New York and Los Angeles broadcasts, which was great for football or baseball or basketball, but you didn't have local networks for news and so forth. And then the FCC, the Federal Communications Commission, started pushing heavily for these satellite broadcasting companies to include local stations in their packages, and so and this was expensive. So there was a proposed merger of DirecTV and Dish Network to reduce their cost, so they wouldn't have to put up more satellites for local broadcasting, and they agreed to merge. And so they had to go through the Hart-Scott-Rodino merger approval process. And here, the Federal Communications Commission was the administrative agency responsible for approval of any merger. Well, when you consider the relevant product market, what are the competitors of satellite broadcasting? Clearly, it was free TV, and it was cable. And to the extent that they were still left, the large television services for the very large satellite dishes, those great big, huge satellite dishes. So when you consider that, DirecTV or Dish Network separately or combined did not have the size that would be necessary for to control price or to control entry into the market. In essence, they wouldn't substantially lessen competition or tend to create a monopoly. Now, that's when you consider the relevant product market on the whole. But the relevant product market has two aspects. One is the market of the product, and the second aspect of relevant product market is the geographic market. And here was the problem for DirecTV and Dish Network. When you consider the outlying areas, the rural areas, the remote areas, and the easiest way to look at it is you look at some place like in rural areas, say up around Kentucky Lake, or a remote Colorado, or Idaho, or Montana, where there are no cable companies providing television service, and you simply just couldn't put a television antenna and get the free television services. It would take sometimes it would take a very large television antenna to do that, and which may be cost prohibitive. So in the relevant geographic market, the combination of DirecTV and Dish Network created a combined firm with too much market share, and there was no way for new competitors to come in. And because of the size of those two firms and the market share that they would have combined post-merger in the remote areas, the FCC declined the merger. Now, recently there has been discussion of a new merger between DirecTV and Dish Network, and because of television broadcasting on the computer and the ability to get computer services, by satellite services, internet services through satellite, and which can be provided by both of those companies, DirecTV and Dish Network, among others. There may be a chance that it might succeed, a merger might succeed this time around. We'll see. Recently, and presently, there's some talk about a proposed merger between two of the largest chemical companies in the world, DuPont and Dow Chemical. Now those two very large companies creating a lot of products that are needed for commerce and industry, it will have to go through this merger approval process as well. In the U.S., under Hart-Scott-Rodino merger. And it'll be interesting to see how that's done. Personally, I think such a merger of two large, prominent companies would stifle patents and reduce competition. Furthermore, I don't believe that the combination of those two firms would pass the merger approval process in the EU. There was a proposed merger between between General Electric and Westinghouse. And of course, both of those companies manufacture electronic devices and controls and things of this nature, large systems and so forth. The Federal Trade Commission and the Department of Justice passed off on it and approved the merger in the U.S., but the European Union refused to approve the merger, and so it put those two companies in a situation in which they could not carry out the merger worldwide because they would not be able to do business in the EU. And if they couldn't do business in the EU, then it was not economically viable for them to have the merger. Lastly, let's look at the Federal Trade Commission Act of 1914. The Federal Trade Commission Act makes unlawful, unfair methods of competition in commerce and unfair or deceptive acts or practices. In essence, they protect consumers. The Federal Trade Commission Act created the Federal Trade Commission that have certain functions. The FTC regulates antitrust matters, rulemaking, investigating, prosecuting, supervision, and adjudication. The FTC regulates unfair or deceptive trade practices under the Federal Trade Commission Act. It's a watchdog for consumers. And here, under the FTC Act, the consumer is the protected party, not business competitors. Lastly, the Federal Trade Commission regulates unfair methods of competition to protect the marketplace from such things as bait and switch. I think this line is out of place. Bait and switch, untruthful advertising. Those would be unfair or deceptive trade practices. So just make a note that those are examples there. Trade disparagement, however, would be an unfair method of competition. This is where you damage somebody else's product. Think, for example, comparative advertising. From the 1970s, the late 1970s, the famous Pepsi trials against Coca-Cola, the taste testing trials, or other advertising that you see where my product is better than your product. This is not like it was in the 1950s and 1960s where everybody's product was compared to product X. You couldn't compare Tide dishwashing detergent with Cheer or Fab dishwashing detergent. It was always Tide is better than product X. The powers of the Federal Trade Commission: they can issue cease and desist orders, meaning an order, stop violating the law and don't do it again or I'll get rough with you, meaning I'll prosecute you. The FTC can obtain an injunction from a court to stop the action and to put a mandatory injunction on the wrongdoer. And the FTC can punish by fine. This would be a civil fine, not a criminal fine. If the FTC believes that a firm's activities warrant criminal prosecution, the FTC will refer the case to the Department of Justice. Now, we'd like to go back to this this part right here unfair methods of competition, and also deceptive trade practices. When a firm advertises, in the marketplace, on television, internet, whatever, then that firm must speak truthfully, right? Not defraud, not mislead. The advertising must be truthful, because untruthful advertising is not protected by First Amendment speech rights. So the FTC, by regulation, can require an advertiser of goods and services to produce the results to prove that the statements made are truthful. And an advertiser is required to have that proof of truthfulness or effectiveness or whatever their claim is before the advertisement is put on the air. To give you an example, you may remember Steve Garvey. He used to play first base in the 1980s and 1990s for the Los Angeles Dodgers. Good-looking guy. He had huge forearms and all that. He was, the media darling back then for the Dodgers. And of course, when he got married, the photograph of he and his wife is almost like, these are the two characters off the top of a wedding cake. They were so perfect. Well, after the playing days, Steve Garvey started making infomercials to at least make an economic gain on his celebrity. And one of the advertising, some of the advertising that he was doing, he and his wife created an infomercial for this firm for a weight loss program. And they advertised it, how effective it is. The wife says that after her baby, she lost so much weight so fast, and Steve Garvey says, I was able to lose a lot of weight and all that. The Federal Trade Commission prosecuted the firm that they did the infomercial for, and also prosecuted Steve Garvey and his wife for untruthful advertising under the Federal Trade Commission Act. And they proceeded. Now, they lost it. They lost at trial, and normally when the FTC loses at trial, they just let it go, but they appealed it. And apparently they lost on appeal. Now, the company, the seller, using this advertising, they reached an agreement with the Federal Trade Commission. They had a consent decree, if you will, in the settlement, but the Garveys did not. The point is that if you are a spokesperson for a product or a service, you've got to be able to prove it. If you say, I use this product and service and that it's helped me, it's been good for me, you've got to prove it. Finally, it should be noted that states also regulate in the area. They regulate competition and consumer protection. All states have consumer protection laws. Laws against deceptive trade practices and product disparagement and unfair competition. For example, in Tennessee has the Deceptive Trade Practices Act that gives a private right of action to consumers injured by deceptive trade practices, and the remedy is treble damages and attorney's fees. Also in Tennessee, consumer protection is under the auspices of the Tennessee Attorney General's Office. This is kind of like the equivalent of the Federal Trade Commission and the Department of Justice all rolled into one. This ends our discussion of antitrust, of the Clayton Act and the Federal Trade Commission Act.